Sitting here in Auckland on the 2nd of December 2013 with Liz Lambert. Liz is a non-practicing solicitor, and Liz is also well known for her voluntary advocacy work with people predominantly who've been hit by credit circumstances, and has been well known for her standing up to the corruption within the banking system and the illusions within the banking system. And Liz has just presented a series of submissions to the Government Select Committee on the credit contracts and enforcement and financial services law reform bill. I'll run over that again in a minute. Got that one wrong. So Lynn has just presented her submissions for the credit contracts and financial services law reform bill, and we will chat with Liz for a while and get this out for people to see somewhere in the near future. Now Liz, your submissions that you have made, you made a great point of pointing out the difference between the owner's equity on a home loan and the bank's interests. And the words that really come out for me out of that was sweat equity. As we know, the owners have had to work and save and personally input their own equity into a property, yet the bank's equity is created by the lender signing their name to a mortgage document which creates a loan. And even as recent mainstream news items have recently been disclosing, often that loan is simply created by creating or inputting those zeros onto a computer screen, and the debt is created. The banks, and I'm biased on this, but have actually advanced nothing. And yet the sweat equity, after the lender has perhaps serviced a loan for several years and has then perhaps fallen on hard times, as we all do. And from my background of 30 years in real estate, I have acknowledged over that time that I have deliberately seen banks attack and escalate the customer's losses, and there is no doubt whatsoever it is not done because it is fair and reasonable. It is done at the very least as a punitive or a punishment to the customer, and I've often felt it was done to ensure the customer could not survive the process. When I say survival, I'm referring to financially, but I think we would be naive not to also know that stress is a great killer, and the suicide rate amongst people who are being taken out in this matter or this manner is also something which is appalling. And the fact that these so-called institutions that spend a huge amount of money enticing us to deal with us and then are prepared to slit our throats, and that's obviously something that you've encountered much of in the battles you've had, and I've been watching the items that have been posted up about you in various news items, and you've done some great work. But perhaps if you want to now go into what your submission was targeting this morning to this committee.
Thank you. Thank you, Russell. The piece of information, the document that I put in front of the committee this morning was something that I don't believe they had seen before, and it was something that was sent to me by what was called a person who's called an arbitrage broker, who worked for the City of London, but he gave it up. He saw the light. Now, the document, which I think you could possibly upload and viewers could have a look at it themselves. In simple terms, it gives you the source of the credit at the highest level. I said to the committee this morning, your retail bank is really quite a way down the food chain in all of this. But to put it in a nutshell, the bank created credit, or the credit which is loaned to us, so-called, is signature created credit. It is not sweat equity created credit. I suppose the closest you could get to any work being done is as you described, the operator inputting those digits into the computer. There is no labour involved in creating that credit. I think there's an interesting idea that our signatures are creating the credit. I think our signatures are creating the input to the authorisation for the credit to be accessed and borrowed from the creators way up the food chain, who are called master commitment holders. Now, I won't go into this much because the viewers can actually look at the document themselves. But what I was suggesting to the committee, in essence, this morning, was that because there is such an imbalance in terms of how much the borrower, how much power the borrower has and the source of their equity compared with how much power the lender has and the source of their equity, that they should set up a tribunal so that when hardship arises, then it can be addressed with that transparent to the view of all of the parties. I also made the point that presently I think that partly the banks make it hard for lenders when they get into trouble, because the first thing the lender is going to do is try to use the present legislation and that the contract is onerous, that the contract, that they have hardship in keeping up with the loan. But they're going to have to, at the first stage, they're going to have to make submissions to file submissions in a court, file a claim in a court, which is, in anybody who's under pressure by banks has not got the wherewithal to do. If they can't pay their home loan, they can't actually afford to engage a lawyer. What I'm suggesting to the committee this morning was that a tribunal system is set up whereby advocates can go to, on behalf of borrowers, and actually negotiate a new contract with the lender, with the view of the disparity of their source of equity.
In your submissions this morning, Liz, you'd mentioned an existing piece of legislation.
Yes.
Whereby people could have some relaxing of the pressure that was currently on. Is there legislation which actually covers that at the moment?
Yes, that's the 2003 Act. This is an amendment. What have they've got? It's a reform bill, but it's actually reform of that Act. That I think it's 2003.
Well, I will have to say to you that
it's not well known, really.
I've never heard of it.
No,
I've absolutely never heard of this.
Well, a lot of the maybe in the hallowed halls of Parliament and in corporate offices all over the country, corporate lawyers' offices, they're very familiar with all of these acts, etc. But the average person who's on the pointy end doesn't have access to them. Well, they can go and look at them online, but you might as well read it in Chinese, because they won't understand it.
Yeah, the person who's under pressure from a bank, one of the first things that happens from the bank is what I would refer to as a head kick, and it's a very deliberate, intimidating head kick, and it shifts from the friendly faces at the retail counter to a complete transformation of this horrendous giant that comes along and just gives you the direct head kick, freezes your accounts. There is no commercial sense in it, what they do. It is straight out directed as a psychological, emotional and a financial sabotage of the customers' lives. And I would have thought, even say with the Section 119 notice of the Property Law Act, which is the notice used to call up the arrears, that not even on that notice, as far as I know, is there any mention that there is another act in place which the customer could perhaps be looking to for some relief.
Right. Well, those Section 119 notices are not issued by the bank, they are issued by the bank's lawyers. Now, the bank's lawyers, and as I was pointing out, perhaps a little obscurely this morning to the committee, that the lawyers are making lots of money out of this. They're one sector of the economy that's doing very well out of it all. There's an economist in the Netherlands actually who talks about the sectors that make a lot of money and draw it out of the productive side are finance, insurance and real estate. I would put in the finance, I would put corporate lawyers in there too. They make a lot of money. I put a supplementary piece of newspaper report into the committee this morning too, just pointing out about how much in the Crafer deal, when Pension finally got their hands on the title, how much had gone into the lawyers' pockets, and it was pretty much the equivalent, ironically, it was pretty much the equivalent of what unsecured creditors had lost out on. Now, those unsecured creditors might be called unsecured creditors, but they are real people with real farm contracting businesses, with real families.
I would suggest to you that the unsecured creditors is actually where the real damage occurs to the country. And by giving the funds as a first priority to the bankers, who in most cases have actually created the situation, is actually treason to the country, because that ends up going offshore as profit and is often created as offshore debt. That is absolute treason to the country. The people whose interests are being looked after are the offshore ones. Now, of course, with the money going out of the country, that directly relates to asset ownership going out of the country. And that's what's really going on.
Yes.
So the local contractors, the local suppliers, etc., the local industry are scuttled. The lawyers get their feed, and the banks scuttle out of the country with the ownership of the assets.
Yes.